Hello, everyone, and a warm welcome to each one of you here on Immigration Talk Show. Thank you so much for joining, and this is your time to share this link with also your friends and folks out there who could benefit most from our content. So ask them to join because we have a very interesting, discussion lined up with our guest for today for sure. And before we start off with everything, let me tell you that our handle is at Immigration Talk Show. So share now, subscribe now. And this important disclaimer before we start. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. And friends, welcome once again. I'm Nipasa, and I'm going to be your host for this session that's lined up. And our guest for today is going to be none other than Jake Tuimaualuga, who is a seasoned immigration attorney with extensive experience helping, Fortune 500 companies, small businesses, investors, and families, who have been exploring the complexities of U.S. immigration system. And he specializes in both business and family immigration and holds a Juris Doctorate from BYU's J. Reuben Clark Law School, where he was recognized for his outstanding work with migrant communities. So, absolutely, friends, without further ado, please help me welcome Attorney Jacob from, US ImmiVisa. Hi, Jake. How are you doing today?
Hey, Nipasa, good. Good morning. Nice to see you. Hi, Felipe, too. Nice to see everybody.
I'm excited for this session that's lined up. And, Jacob, I'm sure it has been super busy for you. So, tell us what has been happening since we last met.
Yeah, it has been a couple of months, huh? I feel like probably like a lot of you, it's pretty jarring to follow immigration news on Twitter or X. With the Trump administration or officials, and so many government leaders posting their thoughts or announcements on social media rather than through traditional channels. We live in interesting times, if nothing else.
Yes, indeed. Very interesting. Every day is an interesting day because we have, different updates, especially if you talk about US immigration. And I hope folks out there have been following us. And if not, this is your chance to subscribe now and stay updated because we come up with everything US immigration. So our handle is at Immigration Talk Show. Check us out not just here on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. Join us to stay connected and also ring that bell so that whenever we have discussions like these, you're notified. And today's discussion is going to be very interesting one indeed. We're going to be talking about why is USCIS taking so long, the latest processing delays and how you can stay ahead. So Jacob is going to help us answer most of the questions we have. And you too, friends, you can ask your questions. Feel free to comment wherever you're watching. And another best thing is, you can also dial in, call us on this number, which you can see on the screen. And the number is 425-436-6335. And when they ask for the access code, just dial 988-888. And I think, Jacob, without further ado, I'm just going to dive right into our questions. So I have this first question for you. How are Trump era changes reintroduced in 2025? And, like heightened national security or screening and cancellation of humanitarian parole as well, which we recently heard, it's slowing down both family and employment based immigration. If you could tell us more about it, please.
Absolutely. I think it's no surprise anyone who's followed the news or the American politics scene. Immigration was probably the forefront issue for the 2024 election. And I think that the Trump administration has shown in its actions that they are evaluating all immigration processes, both legal traditional means and through illegal immigration, as ways, frankly, to deter both. I think we've received a lot of mixed messages from the administration with regards to legal immigration. I think it's no surprise that the administration was targeting crime and trying to prevent what they perceived as unlawful entries into the U.S. But I think there is a battle within the Trump administration between those who also want to limit legal immigration as well. And I think, like you've pointed out, Nipasa, there has been a lot of announcements or actions taken to, at the very least, slow down all immigration processes. I think this is across the board, both with USCIS here domestically and with the Department of State abroad, where, I mean, literally before this morning, F1 visa appointments were not even available for weeks or almost a month. So we're basically checking these sorts of updates every single day to see what's going to be next.
Right, Jacob. Thank you so much, for giving us a peek into what is happening. And yes, these updates have been going on, and we have a lot of confusion, questions, and it's only, very how to say obvious that people have a lot of questions for us to answer as well. So I'm happy that we have some viewers who have joined us already, so I'll quickly say hello to them. Ricky, thank you so much for joining us, and also Philippe, thank you for joining us on LinkedIn. He says good morning, Jake, and hello, I am from Nepal, he says. So it's lovely that you have joined us. This is Netra from Nepal on LinkedIn. Lovely to see you. Thank you so much for joining us. I hope that you're going to enjoy this whole session that's lined up. And feel free to comment if you have any questions, especially with regard to the topic of discussion for today. And Jacob, now my next question to you is, USCIS has now expanded also the biometric requirements to additional categories, including the H-1B and the I-539 applicants. So how much is this new step contributing to longer processing timelines?
It's a really good question. I actually think the rollout of this was not streamlined properly. If you look at the announcements for this biometrics announcement, they said that if you had an I-94, which for those who are not familiar, you get an I-94 if you enter the US with a temporary visa or another type of entry document. You're given this document online or in your passport, most commonly online, which tells you how long you're allowed to legally remain in the US. And the announcement said if you have received this record, you are not required to file the updated biometrics request. And the way you do that is through something called the G325R. You do it online. But for example, I had a national interest waiver applicant, a couple of them, who received RFEs for their cases. Nothing about the merits of their actual NIW case, but solely requesting that they provide this biometrics data, even with their I-94s, where they were on an H-1B or an E-2 visas, which give you I-94s, but they were still given these biometrics requests. So I think it's, I think in principle, it's a good idea if you're trying to vet travelers through the US. I can understand the intent behind it. I think the execution could certainly be done better. So is it contributing to longer processing times? Yeah, no doubt.
Yes, definitely is. And we can see that almost in most of the categories, I think, right, Jacob?
Yeah.
So,
Yep. That would never have happened for a petition. Like for a change of status, it would make sense for like derivative applicants where they need to do biometrics. That has been done in the past. But for a strict petition where you're not even asking for a status change for you to have to provide biometrics, that's never really been done.
right, right. Thank you so much, Jacob, for taking that up. And I do have more questions. And Jadav has also joined us. Jadav, thank you so much for commenting with your question. We are going to take it up a little later in the show. So stay with us, all folks out there watching us right now. So also, Jacob, I have more questions. And if you could tell us, because with reports of tighter scrutiny and more frequent RFEs, across applications in USCIS, um, is USCIS becoming more risk averse in its adjudications?
Absolutely, yes. The rate of increase in RFEs, I think it was more than 20% of non-immigrant visa applications overall receive requests for evidence. This is based on anecdotal reported data, but this is up from 3% from the Biden administration for around the same time last year. So undoubtedly, when you start to see more requests for evidence across the board, you can tell that USCIS is trying to more heavily scrutinize applications. I think we've also seen this too with regards to green card processes, where in the last 4 or 5 years, really since COVID, we were not getting very many adjustment of status interviews at all. So for those who don't know, adjustment of status is where you change your status from temporary to permanent residence in the US rather than get your green card or your visa through the consulate. And so last few years, a lot of people, I would say 95+% of our clients were just getting these in the mail, and you never had to talk to an officer. Right now, we are kind of flooded with a lot of these interview appointment notices, even for EB1 and EB2, EB3 green card applicants, through employments, not just the marriage-based ones. So, yep, there is definitely higher scrutiny.
Well, thank you so much, Jacob, for taking that up as well. And very interesting, I feel, this whole conversation we're having. And there's so much more to ask. And Philippe Caesar says hi to me too. So hello to you too, Philippe. Thank you so much for joining us. And well, we are going to take up your questions. Stay with us, and please feel free to share this content with your friends and family out there who could benefit most from this conversation and discussion today. So we'll just go for a quick short break right now. And do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. Today we are speaking with none other than attorney Jacob Tuimaualuga, and we are talking about why is USCIS taking so long, latest processing delays, and how you can stay ahead. Don't go anywhere. This is Nipasa on Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMMI Support.
Welcome back, everyone, on Immigration Talk Show. And I'm Nipasa, your host on today's discussion. We got none other than attorney Jacob with us today from US ImmiVisa. And it's been superb having him because we are already, getting most of our questions answered. And we are talking today about why is USCIS taking so long, the latest processing delays and how you can stay ahead. So if you too are facing processing delays, maybe you have questions with regard to your visa status, feel free to comment or maybe join us on call. Our number is 425-436-6335 and the access code is 988-888. So Jacob, I have more questions for you and I'm just going to go right into it.
Let's do it.
Which USCIS forms are currently facing the longest delays, if you could tell us? And for example, why are I-130s for green card holders now exceeding 36 months, while I-129 for fiance visas are moving comparatively faster?
Yeah, I'd say for the most common forms, the ones that I've seen that the processing time is just lengthened to crazy levels, is probably the 601 waivers. Those are basically if you've otherwise violated your status or if you have unlawful presence and you need to ask for forgiveness through a qualifying relative. Before COVID, I remember those taking around 6 months or so for them to process. And now there are several of them, like these types of ones are taking more than like 2.5 years for them to process. So basically something that's, I would say, an unacceptable processing time. I think the one that's probably the worst is also the I-751. So this is to remove the conditions of your green card to get the permanent one. I think the fact that, it's a very quick, easy form. The fact that that takes more than 2 years to process is crazy. With regards to the I-130s compared to the I-129Fs, on a personal level, I really hate that these take that long. I feel like the the need for family unification is very important. So I think the idea that, I could be sponsoring my wife, my kids, or my fiance through the I-129F, and I need to wait 3 years for their petition to get processed before I've even gotten to the consulate is ridiculous. I think that's extremely inefficient, and I don't think that helps Americans, who are trying to help their family. So yeah, those are a lot of those delays. There are certain actions, I'm sure we're going to talk about those, that you can take to try and speed these up. If I was being honest, I would say a lot of these actions were more effective in years past than they are right now. If it's any consolation, though, I will say last few years there has been, I would say, a back and forth between whether a fiance visa or a spousal visa was faster. And there are definitely some advantages where you would choose one over the other. Right now, my experience just with my own clients, the fiance visas are definitely processing more quickly than the spousal visas are, though.
Right. And like you said, very, very, very true that, families need to be reunified sooner than later. I think it's very important for families to stay together.
Yeah.
So let's see what happens. And if I may ask, Jacob, all these years of experience on immigration, law, is this, I mean, are these delays, have you seen these sort of delays earlier or more delays anytime earlier?
Um, no, I was trying to think if there was a time that I had. I would say COVID was pretty slow for sure. There was less reduced capacity there. Um, I think one factor is there are more people applying now, and there have been in the last few years than there were ever before. So I can understand in a limited capacity why there are delays. But I also think with the advent of technologies and AI and modernization, it really shouldn't take that long for a lot of these types of basically procedural, respectfully, secretarial work for decisions like this to be made. A lot of these types of applications, it's not even possible to file them online. You have to print these off and mail these in, and somebody literally combs through your paper in order to make a decision. I'm like, it's 2025. We should be able to modernize a lot of these systems to just make them more efficient. But alas, we have what we have.
So true, so true. That's what, even I had in my mind, because it is modern times. Most things are digitized where everything is online, and,
Right.
it's more like saving time and faster, right? Where messages or documents rather do not take so long to get through. But I agree. You still need manual labor behind all of that. So it should take some time. And I think people are traveling now more than ever before. So
Yep.
that too adds up, I guess. So
Yeah.
quickly, though, I'll say hello to Seema. Thank you so much for joining us, Seema. We are going to take up your questions. Stay with us. But Jacob, I have another question before we proceed with
Yeah.
our questions from our audience. Despite border backlogs, the N400 naturalization applications are being processed faster than in, recent years. Why is that? And can this trend continue?
I've definitely seen a marked increase in the speed of processing citizenship applications. Probably in the last year, maybe 2 years or more. I've had several cases. I practice here in Utah, as where we're based out of, and I've had almost all of my citizenship cases were processed within like 2 to 3 months, sometimes even faster than that. I think a lot of people suspect that this is because of two reasons. One, the fees that they earn from citizenship applications are pretty high in comparison to the actual work of what the officers need to do. Those applications are pretty quick to review. It's pretty easy to determine whether somebody's qualified or not. So that's nice. The second reason I suspect is that allowing people to apply for citizenship also helps for voting purposes. And there's a big incentive for that to be done as soon as possible as well.
All right. Thank you so much for taking that up, Jacob. And we should address some of our questions from our audience. They've been waiting since we began this discussion. So let's take up Ricky.
Yeah.
Can you give some idea on the typical processing time that you are seeing for NIW based I-140 petition? My NIW based I-140 petition is pending for last 7 months. So do you suggest filing premium processing at this stage, or should I wait for 1 more month? Also, can premium processing increase chances for RFE for NIW I-140 approval? If so, by how much will the chances of RFE increase?
It's a great question, Ricky. Yeah, if you're at 7 months of waiting right now, if this was 2, 3 years ago, I would tell you it's going to be any day now. Right now, it's probably closer to 14, 15 months for them to adjudicate initial submissions. Personally, I think I shared this in previous videos together. I'm not the biggest fan of premium processing. I think that one, it's very expensive for what it is. You're paying almost 3,000 USD. And for an NIW, it's 45 business days for them to make a decision. I mean, that's basically 3 months that they're going to take to process your application. The other reason why I'm not the biggest fan of premium processing, well, two reasons. One of them is it does, based on our firm's own data, increase your chances of receiving a request for evidence. By what percentage is up for debate, I would say it's significant enough for it to not be worth it, in my opinion, in a lot of cases. Now, if you have a very strong case, or if you have urgent reasons why you could benefit from premium processing, let's say you have H-1B, your spouse has an H-4, you don't have an approved I-140, and you want her to have an EAD, might be worth it for you to do premium processing. Or if you are also super rich and you have a lot of money and $3,000 is not that much to you, go for it. Why not? Otherwise, I like for USCIS to really take the time to review your evidence without the time-sensitive pressure of having to make a decision or give you your money back. Because I can tell you, they don't want to give you your money back. So you are likely to get an RFE if your case is not very strong and you file for premium processing.
Yes, for sure. And Ricky also has a follow up. If NIW I-140 petition filed by the employer is pending, can I file another NIW I-140 in parallel myself while the other one's still pending? Will this create any issues?
Great question. Nope, no issues at all. You can file as many separate immigrant visa petitions that you want, as long as there's not any, let's say, conflicting claims or information. So, for example, I had clients in the past who had submitted certain visa applications previously before moving forward with one with me or with my firm, but submitted different experiences or submitted or different claims regarding the dates that they worked in certain places. That would be problematic. But assuming all else being equal, you're submitting the same truthful facts, go for it.
All right. Thank you so much, Jacob, for taking that up for Ricky. And folks out there, do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. Ricky, I hope you got your answer. Don't forget to also ring that bell icon and share this with your friends and family out there who can join us and benefit most from this content. And best thing is that they can also join in to ask their questions, and you can also dial in. By the way, the number is 425-436-6335, and the access code is 988-888. Join us. So now let's go with Philippe. Oh, Philippe already taken. Netra, really, I wish you could join us on call, but nevertheless, if you have any questions, let us know. And Jadav. Jadav is asking, I've been waiting for my application to be processed for months now. Can you help me understand what factors are contributing to these delays? Is there anything I can do to speed up the process?
Yeah, sorry, Jonathan, for the wait that you've been experiencing. It would depend on the type of case that you have as well. Historically, there are basically 3 steps that I would try and take to move an application forward. Depending on case type, there might be more, but these are some of the actions I would do. Number 1 is to file an e-request with USCIS. Basically, if you Google e-request, USCIS, you'll be taken to a page that allows you to submit a request if your case is outside of normal processing times. I'm going to be very transparent with you. Most of the time, this step is completely useless. It usually doesn't lead to any good action, but you will receive a service item ID confirming that you have made this request. And this is something that could help you in the future, at least to show you have been trying to get the agency to take action. Number two, you can contact USCIS directly via their Ask Emma option, or to call them and ask to speak with them, and to request expedited processing depending on your case type if you have an urgent reason to justify it. Some of these would be if you have urgent humanitarian, medical reasons, or other significant hardship that should be considered. Okay, so I've seen this type of request done for advanced parole, for travel, and for employment documents. Usually I haven't seen this for petitions. Historically, the other thing we would use is something called the Ombudsman's Office. That was defunded through the Trump administration, so that office no longer exists. The last couple of options that you could do would be to seek congressional assistance. So if you live here in the States, you have a congressional representative through the House of Representatives, and you have a Senate member as well through the US Senate. In either case, I'm very certain that your representative or senator has a page on their website that says help with a federal agency, and you could submit this request to ask for their office to help you. In times past, I've had this work where, here in Utah, I had a previous senator help to bring somebody home who was stuck in a foreign country and who's been waiting a long time for a case. So I have seen it work in the past. If I was being honest, there have been mixed results in the last year or so. The last thing I'm going to say, sorry, this is kind of long-winded. If all else fails and you have attempted, all of these steps to try and compel USCIS or the Department of State or whomever to make a decision on your case, and they have still not, and you have suffered some form of irreparable harm, or there's some other urgent reason why they need to make a decision, you can, in some cases, bring your case to federal court and ask for a judge to compel USCIS to make a decision. And this is through something called a writ of mandamus. This, in my opinion, would be the last option you would do if you have an urgent need. So, for example, I've had clients in the past where they filed petitions and had waited years for immigration to make a decision, way outside the process. It was a marriage-based case that took like 9 years for them to make a decision on I-130. That's ridiculous. So by filing this claim, you're essentially saying that USCIS has, for lack of a better term, neglected their duty, and that they need to have the courts to compel them to make a decision. And then by doing so, USCIS will make a decision on your case. So hope that helps.
Very helpful. Thank you for the detailed explanation for Jacob. And folks, don't forget to subscribe to our channel. Our handle is @Immigration Talk Show. I hope you're enjoying this whole discussion we're having today. And it's really lovely that Attorney Jacob is so patiently taking up each of our questions and answering them. So don't go anywhere, because we are definitely going to take up more questions. I can already see Netra's comment with a question. I'm going to take up this question right after this short break. So don't go anywhere. Stay tuned here on Immigration Talk Show. This is Nipasa with Attorney Jacob.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMMI Support.
Welcome back, everyone, on Immigration Talk Show. I'm Nipasa, your host, And today we are having an awesome discussion with Attorney Jacob from US ImmiVisa, and we have been speaking about why is USCIS taking so long, latest processing delays, and how you can stay ahead. And it's lovely that Attorney Jacob has been taking up each of our questions and answering them patiently. And before the break, I told you that we are going to take up Netra's comment. I believe Netra is from Nepal. So thank you so much for joining us here on Immigration Talk Show. If you haven't as yet subscribed, subscribe now. Our handle is at Immigration Talk Show. This goes out to everyone watching us, by the way. And Netra is asking, we are four in family and master in management and science. Children are under 20 years. Tell me the best and cheap way to PR USA.
Hi, Nedjari. This is a great question. I'm going to use the lame lawyer answer and say it depends. I would say if you don't have like in a perfect world, if you have an American company to sponsor you, to bring you to the US to work in some capacity related to management and science, your background, that would be the best and cheapest way because one, it statistically has the highest chance of approval, and two, it's the cheapest way because you're not the one paying for it. So that is also a great benefit. Now, assuming neither of those apply in your case, you're going to have to look at the self-petition options. And the immigrant visa ways for you to do that would be through the EB-1A, the EB-2 national interest waiver, or the EB-5. I'm going to go ahead and rule out the EB-5 for you because it is not only not the cheapest way, it is the most expensive way. So you would probably not want to consider that one. EB-1A is a self-petition for those with extraordinary abilities in their field, usually considered for those who are in the top 1% to 2% of their profession. Statistically difficult, not impossible for it to be approved. I would say in your case, based on what you've said with your educational background, you have a master's degree. Assuming it's the equivalent of a master's in the US, you would be qualified for the EB-2 classification. And if you can show that you have future work in the US that is of national importance and substantial merit and that you're qualified to do this work, you'd probably want to look at the EB-2 via the national interest waiver. Now, to be transparent with you, if speed is your concern, this may not be your number one option. In years past, this was much faster of a process for it to go through. But right now, if you were applying from Nepal, I would say you're going to be waiting at least 2.5 years for this to process if everything goes well. So if you are interested in immigrating to the US and working here beforehand, you probably want to look at a non-immigrant visa for employment or investment first before doing the national interest waiver.
All right. Thank you so much, Attorney Jacob, for taking that up for Netra, all the way from Nepal. I hope that was helpful. And I would say please feel free to contact Attorney Jacob. The link is going to be displayed on the screen. Click this link and you will get the contact details to have a one-on-one consultation even with Attorney Jacob Tuimaualuga from US ImmiVisa. So it's lovely having you, and we do have more questions. So let's quickly take them up. This next one is from Harsi. I'm just going to say Harsi. It's asking, my priority date is 21st June 2006, document qualified 30th December 2024, F4 category, India. When to expect interview?
This is a really good question. I'm going to check the bulletin right now for the F4 category. Give you my estimate there. Yeah, so you're obviously your priority date is already current there. You're interviewing in India. Let me look and see what was the last time that like the estimated processing time that we had for consular processing there. So in a couple of countries that we work with, we've seen some pretty significant delays even after being documentarily qualified. I would say in most cases, usually ends up being somewhere between 2 and 6 months. Now, there's a couple of countries, I would say Nigeria, Chile are the two that most clearly come to mind, where even after being documentarily qualified, I've still had guys who waited a year for them to have an immigrant visa interview. So I'm hoping in your case that it does not take that long, hopefully only a few months, but it would be difficult to say right now.
Well, thank you so much, Jacob, for taking that up. And Harseem, I really hope that was helpful. And please feel free to also contact Attorney Jacob. And the link you can see on the screen, click it, and you will have his contact details. Thank you so much, Jacob. Now let's take up this one from Philip S. Thanks, Jake, for your flexibility in helping us with our legal issues. July 10, my NIW petition is going to be 1 year since I submitted. I'm going to take your advice and just wait, he says.
I know, Phil. He's a good guy. I appreciate that. Yeah. I'm wishing you the best of luck, my friend.
All the best, Philip, from my end as well. And now let's take up Seema's comment. Seema's asking, has a question. I'm seeing conflicting information online about USCIS processing times, and it's really confusing. How can I get accurate, up to date info about my application's status, and what are the best ways to track it?
Very good question. I would agree with you on this. So the most common resource that people use is the case processing times estimate from USCIS that they make publicly available. In my opinion, these are not reliable at all, and I think it's intentionally that way. In my experience, the relevance of these posted processing times is so that way USCIS has a defense for if you try and sue them under a mandamus action, they can say, hey, it's still within processing times. Our processing times are 36 months. Sorry, you need to wait until then. Even though in practice, they're approving most cases far quicker than that. They have that in there as an insurance policy. That's my opinion. Now, I would say the best way to track it is through personal experiences and reported data from users who are actually in it. And there are several websites that I like to reference for this. There is one called Track It online. I think there's 2 T's on there that I would look at, where people share anecdotal, like their personal data, as a way to give a more true estimate of the estimated processing times of cases. I also like to use even social media reports from people who are filing themselves. I will say on a personal, yeah, there we go. Thanks for sharing that. Yep. So it's www.trackit with 2 T's at the end.com. This is one that I have seen a lot of people use. I like that there is, compiled data here to track this with real people who are applying. But yeah, if you didn't want to pay or use this, I think there are some of these that are paid services. I don't know if this one was specifically, but if you didn't want to, I would also just check with social media, and I would ask, lawyers or those who work in the system to just give an estimate based on their personal trends. It may differ from your case, but at least to know what the estimates are.
Approximately. Thank
Yeah.
you so much, Jacob. Yeah, that was very helpful. And folks, do check out that website. And thank you, Seema, for participating with your question. Folks out there, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. And feel free to also share this with your friends and family so that they can also subscribe. Ring the bell icon so that whenever we have discussions like these, y'all can join us and ask your questions. And yes, thank you so much, everyone. Now let's take up, well, Hari Sim is here with the continuation. He wanted to also update you that I also get 60 days mail from NVC, sir, he says.
Oh, sweet. Okay. Then, yeah, I would keep in contact with them via email as well. If they're already giving you the 60 days out from your appointment or from when to expect correspondence from them, I would definitely stay in touch with them because you're probably very close to the actual appointments. And the next step, they will ask you to go and get the medical examination before your immigrant visa interview. So you're almost there.
That's nice. Harsim, all the best. And I think it's your time now. So get
Mhm.
it done. All the best. And please don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Now let's take up this comment from Nirav. If I'm waiting for a decision on green card and the delay is affecting my life plans, is there any way to get expedited processing? How do I know if I'm eligible for that?
Yeah, sorry, Nuram, it's not fun. Um, it's going to depend on your individual case circumstances. The only one who can ultimately determine to expedite your case is USCIS. Particularly, I'm assuming here that your petition's already approved and you're either waiting for your immigrant visa abroad or your adjustment of status here in the States. In either case, I would, that's kind of a lame answer, I would talk to an attorney then just to see what your facts are. If you didn't want to do that, you again don't have to. You could contact USCIS, whether through their online accounts or to call them, ask to speak to a representative through an InfoPass appointment, and explain the reasons why you need expedited processing. I'll be honest, I've seen a lot of these requests denied where they don't consider them to be justifiable reasons, but sometimes they will grant these. If you can explain the reasons why you would need to have this process expedited. I would say in most cases, you're more likely to get your work permit or travel permit expedited than your actual green card, unless you have, again, a pretty justifiable reason. For example, if you were working for the US government in some capacity or in some important, let's say, tangentially related to a government interest, or you had some urgent medical need or other humanitarian reason, those are the reasons that I would say are most likely to be approved for expedited processing.
All right. All right. Thank you so much, Neera, for commenting. And thank you, Attorney Jacob, for taking this up. Folks, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. And if you need a one on one consultation with Attorney Jacob Tuimaualuga, do not forget to also visit this link, which is displayed on the screen. And yes, please feel free to share this content with your friends and family so that they can join us in this conversation. Comment if they have questions, because today we are discussing on this topic: why is USCIS taking so long? Latest processing delays and how you can stay ahead. You don't want to miss out this opportunity because, yes, this is very, very beneficial content and content you don't want to miss out on. For now, though, we'll just go for a quick break, and folks, don't go anywhere. Stay tuned on Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMMI support.
Hello, everyone, and welcome back on Immigration Talk Show. I'm Nipasa, your host, and today we are having a wonderful conversation with none other than Attorney Jacob Tuimaualuga from US ImmiVisa. So it's been wonderful having you, Jake. Thank you so much for doing the session with us and for patiently taking up all of our questions today. We are discussing on why is US taking so long, the latest processing delays, and how you can stay ahead, and we have been taking up comments from our audience. It's really lovely to have all of your support and your questions. So let me just quickly pick them up since we do have more questions from Harisim and Philip who have joined us back with follow ups. So, Harisim, sir, can you also tell which document qualified are getting interview in F4 category?
If I forgive me if I don't understand your question, I'm assuming you're referring to siblings of U.S. citizens. Can you tell which document qualified are getting interview? Yeah, basically everybody who's applying for an immigrant visa, who's over age 14. So if it's you and your spouse and children, and you're waiting for your interview, if your kids are over a certain age, they will need to be there in person for that. So that's what I would be prepared for. I hope I understood your question.
Thank you for taking that up. And now Philip is asking, my work was terminated because of my expired work permit. Can I request an expedited request?
It's a good question. I think it would depend. If your work permit was through OPT, the occupational practical training, because you have an F1 visa, the expedited request, I'm assuming if you mean on your NIW, it would not be helpful for you to do, because having the approved I-140 would still not allow you to get a work permit in and of itself without having a current priority date or another visa type for you to do. Now, if you had H-1B, or if you have, let's say you're married and you have a H-4 work permit, then it would make sense for you to do an I-140, like the expedited request for NIW, because getting that would allow you to apply for a new one. Otherwise, though, there's just not really a benefit in doing that. I'd say the only other reason you'd want to do that is if you have an employer who says that they'll sponsor you for a work visa, or a temporary visa if you have an approved I-140. Otherwise, I still don't think it'd be that helpful.
Right. Well, thank you so much, Johnny Jacob, for taking this up. And Philip, I hope you've gotten your answer, and I hope everyone watching us is resonating with what we are discussing today. Please do not forget to subscribe. Our handle is at Immigration Talk Show. And we do have more questions, actually, Jacob. From I had many questions from my end, but looks like I'm not going to get a chance because there are so many lovely viewers out there with so many questions for you. So let's take these up. These are from our Facebook groups. So I would request control, please, display them on the screen, and we will take them up.
Okay, let's do it.
All right. So meanwhile, I think we can all right. So we have these questions. This is from an anonymous participant asking, has anyone been stopped by ICE? What do you show them if stopped? My lawyer said the pending case letter where they approved it and shows we have to be here. But will they respect that?
Very good question. Has anyone been stopped by ICE? Yeah, but I would say quite a few people. A lot of people have been stopped by ICE, Immigration and Customs Enforcement, nationally in the States. If you are stopped, you do have, if you're physically in the US, you have the constitutional right to remain silent. If you choose to invoke that right, you should be aware that you will eventually be required to provide proof of lawful status here in the US. Otherwise, you will be placed in removal proceedings. What you should show them is proof of lawful status here in the United States. or other proof that you are allowed to remain here. So for example, and the most clear example of this would be if you have a green card or a US passport, right? If you're a resident or citizen, obviously you're entitled to be here. If not, you should have an I-94, which you can get by using your passport and Googling I-94 record online, and you can find what your I-94 date is. On that record, it will tell you how long you're allowed to legally remain here. Let's say you don't have that though. If you're physically in the US and you filed for a change of status legally here, you are allowed to remain here legally for the duration of that process, as long as that process is still pending and the time you requested to extend is still ongoing. For example, if you entered as a tourist and you were here in America for, let's say, 3 months, and then you wanted to be a student and you filed for this change of status, you would want to present to ICE something called the I-797C Notice of Action, which shows that your I-539 for the change of status is still pending. From a long story short, you just need to show them some documents to show you're allowed to be here. If you're unsure what this is, please feel free to contact me or an attorney, somebody who knows what they're talking about, and they can tell you what you should bring or have on hand.
Well, thank you so much, Jacob, for taking that up. We do have more questions. Let's take up this next one quickly. This is also from an anonymous participant asking, my case status until yesterday was saying next step is an interview, and today it says your application is pending. What does this mean?
Very good question. I have seen uncommon case statuses online for USCIS lately. Normally, the next step as an interview would apply for a family-based, most commonly for a family-based adjustment of status case. Your spouse, child, etc., is sponsoring you to change your status from temporary to permanent resident here in the States. If it does change from that to your application is pending, to be honest, it suggests that they're likely reprocessing part of your application or reviewing it. I've had some instances where they approved the I-130, the family-based petition, and then reopened it because there was a new piece of evidence that the officer needed to consider. Now, that doesn't mean that's for sure what has happened. It may also mean that they are just not going to give you an interview, which would be nice in 2025. I would just continue to check your case status online every day until you see a new update on there. I hope it's a good one. Good vibes.
Thank you, Jacob. Thank you, David. So now we have more questions. This is another one asking, on submitting my DS-160, I got the following message. An unexpected error has occurred while processing your previous request. The error has been reported to the site administrator. No further action is required. To retrieve your DS-160 application, please enter your application ID. Has anyone encountered something like this? If so, how did it get resolved?
Okay, I can definitely comment on this. This is anything but an unexpected error. If anything, this is very expected. This happens all the time with a DS-160 website. I kid you not. I think this is the worst website I have ever seen. That is supposed to be a functionally used by people on a daily basis. Regardless of browser, you are likely to see this. So my advice on this, my guidance on this would be to save every page that you do on the DS-160 and be prepared that you will get this message, if not once, multiple times, every time you do this. If you're having, I will say a lot of times I've experienced this on Chrome, and then I'll switch to Safari. I use a MacBook and it will work. Oftentimes I have to wait until the next day for it to work. And sometimes this may continue 4 days. I would try with Mozilla, I try with Chrome, I try with Safari, I try with Internet Explorer, and wait for time. Those are basically the only things that you can do, unfortunately.
Okay, that's interesting. And well, thank you for taking this up. I think this is a frequently asked question then. Yeah. This next one is from Carlos asking, I just talked to a DHS immigration officer and he stated that EB1, EB2, EB3. Adjusting of status I-485. Interviews are back. No more green card approvals without interviews. Do you know if someone already went to one? Thank you.
Yep, I've been to many just in the past 6 months. I would say even from before President Trump came into office, this was starting to become a more common uh, practice. Is definitely happening more so now, and this is for across the board, the self petitions and the employer sponsored ones. I would just be prepared to bring all the documents that are listed on the interview notice. I have several ones that are upcoming too. Got an EB3 interview this next week too, and I'm going to have my client bring all the documents listed on the interview notice and be prepared to discuss the employment and the information listed on the labor certification and on the I-140. I remember being in these interviews even when President Trump was in office last time, because prior to that, it was still not common. It was not common before that for these employment-based interviews to be ongoing, to occur before that. So yes, they're happening now. You just need to be prepared to answer their questions pertaining to your employment.
Right. Thank you so much, Jacob, for taking that up as well. And well, we do have more questions. I wonder if you have more time with us, Jacob.
Let me finish the questions on here. I can do it.
All right. So this is from JP asking, my PD is 28th August 2023. What happens when it gets current and how long you guys think? Sorry, it's getting cut off. Control, if you can zoom out a bit. Uh, Less will it be? How how long you think more or less will it be?
It's a great question. I tried to have everybody file within the month that your priority date is available to file the adjustment of status, assuming JP that you are here in the States. You do not want to let it go into the next month because you don't know. Well, you will find, you can check the next month's bulletin, right? But oftentimes the retrogression can happen where you'll lose the ability. I know many Indian applicants who suffer the retrogression who were unable to take advantage of adjustment of status during 2020 and 2021 because they did not file the adjustment of status on time. So there's the saying, a bird in the hand. I can't remember the rest of it, but you want to take it when it's available. So you want to make sure you file the I-485, even if you don't have all the evidence that you need. I would make sure you file the bare minimum to get accepted. The medical exam, the 485, the fees, etc. Even if you get an RFE, make sure you get it in.
There you go. Thank you so much for taking this up. And folks, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. I hope you're resonating with this conversation we're having and with all these answers that Attorney Jacob is so patiently taking up and answering. So this one is from Tatiana asking, hi everyone. I'm currently with my B1 visa and applying to F1. My visa expires in July 28th. My question is, what happens if past July 28th, my request of status change has not been answered yet? Can I stay legally while waiting or should leave the country?
Great question. Tatiana, you should know if you leave the country and you file a change of status, it will be considered abandoned. It will not be approved if you leave the country, for sure. You are legally allowed to remain in the United States while your F1 change of status is pending, as long as you file the change of status before July 28th. Even if you filed it and it arrived with USCIS on July 27th, you are allowed to remain here while that process is, specifically for the F1, because you would have requested that your F1 status be valid for the duration of status. That's D/S on this form. As long as your I-20 is valid, even if it takes 6 months for your F1 change of status to be approved, the F1 change of status will still be approved, and it will be predated back to the time that you had filed for the change of status, assuming you asked for the F1 to start on July 28th. The risk here is that if it's not approved, you need to make sure that you depart after the I-539 is denied. A lot of times for my clients, I have them file a B1 extension as well, just in case the change of status application is not approved.
All right. Thank you so much for taking that up for Tatiana. Now, this next one is: did anyone cross borders to get F1 stamp from his home country, US Embassy, after applying for change of status inside the US? In my case, I applied for I-539. I want to travel home by end of this year, but I am really afraid to lose my status and not be able to return back again. I really want to hear your experiences about that, and which country did you get your stamped F1 from?
Yeah, this is a complicated answer, to be honest. So, for those who do not know, filing a change of status in the US does not govern for the Department of State. So, in theory, you can have an F1. Let's say you enter as a tourist and you apply to change your status from tourist to student here in the US. You'll get a green piece of paper saying, congratulations, you now have F1 status here. If you take that document and fly to Mexico for vacation and try to fly back with that green piece of paper as your visa, they are not going to let you back to the country because it's not a travel document. It's not a visa. It is not without its own risk for you to leave the US with a change of status and to pursue a visa abroad. I would say in this case, in your case with the F1 stamping, it's going to depend on a number of factors whether it's worth the risk for you. So I've had some clients in the past who came here as tourists many years ago. Like I had one client who came in like 2013 and filed for a change of status to F1. And he had been on F1 for 10 years before going back to his home country in South America for a visa. He had no property and he had no family, no spouse, kids, parents, nobody that lived back in his home country. When he went back to that country, he was unable to get the F1 visa stamped there because they did not believe that he could establish ties to his home country. This is really country and fact specific. Now, alternatively, let's say that you own a house there in your home country, you have property and money and savings and a business and kids, whatever. The more context you can show there and the more frequent your visits back home, the better in your case. Again, any case specific things, I would talk to a lawyer about this, but it's really going to be case specific.
All right. Well, thank you so much, Jacob, for taking that up. And I think we are going to take up these last two questions. Or, folks, maybe if you want or have any questions, quickly comment now. This is your chance. And we are going to leave soon. So, this next question we have is on YouTube, Inner Dry. Thank you so much for joining us. Don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. And also feel free to share this with your friends and folks so that they can also join us in these conversations and benefit most from our content. So Inner is asking, last year H1B I-797B approved and active, but has consular 221G and it's in refused status. Employer need to submit more documents. Can any other employer file a cap exempt H1B for me based on approved I-797?
If you were H1B, if you were fiscal year 2024, so you had it approved October 1st, 2024, or fiscal year 2025, and you were approved October 1st, 2024, yeah, have another employer file the cap exempt H1B for you. You could also do that based on that approved I-797.
Thank you, Jacob, for taking that up. And this next one is from a ranger. I have a pretty forward case, no arrest, no removal overstay, but back in status, DPS. How much do you charge for AOS? Thank you.
Nice. Yeah, I mean, transparently, I would say here in Utah where we practice, I would say most firms, including ours, it would be somewhere between $3,000 and $4,000, counting the AOS appearance with USCIS as well. I think if you were price shopping, you could find a more affordable option than that. But if you were looking for support and for someone to attend the interview with you or respond to any requests for evidence, super happy to do that. You did mention you have a straightforward case. If you have TPS, you have lawful entry, you have no arrests or other inadmissibilities, you probably have you got a good straightforward case. I don't think you'd have too much trouble at all. You should definitely do the adjustment of status.
Thank you so much, Jacob, for taking that up. And folks, please feel free to contact Attorney Jacob from US ImmiVisa, and you can do so by checking out this link, which is displayed on the screen. And also, Jacob, today so much to ask, so much to speak about, but I think we will have to keep some of our questions for another session. We have been discussing on, why USCIS is taking so long, the latest processing delays. But also, if before we go, you could quickly just give our audience out there, viewers out there, a few tips on how you can, or they can stay ahead rather. So that would be great.
Yeah. Immigration is an ever evolving field, probably more so now than ever. Feel free to follow us online, follow other accounts, follow this channel for updates on this. I would just remain informed. If you do have delays or you're worried about case processing, I would say, take heart. Yeah, there might be some setbacks. Yes, there might be some processing delays, but there's usually more available. There's usually more things that you can do than you think. Sometimes you just have to be creative, or might just have to do a little bit more work than you realize in order to reach your desired goal. But I would just, where there's a will, there's a way. If you have any other questions or anything else, please feel free to reach out.
Thank you so much, Attorney Jacob. It was really lovely having you. And Ranger is having a big question out there. And I think you should definitely contact Attorney Jacob, and you can do so by checking out this link. Contact him and have your consultation with him. I'm sure he's going to be most helpful. It was really lovely having you today, Jacob, with us.
Appreciate you, my friend. Always good to see you. Thank you.
Thank you so much. I wish we could continue, but let's leave some of our questions for our next episode. And folks, do not forget to subscribe to our channel. Our handle is @Immigration Talk Show. I hope you loved it just like I did. And thank you everyone for joining us. Also, if you want to contact me or you have any questions which I can, send them across to Attorney Jacob, also you can write to me or call me on my number. This is also my WhatsApp number. My number is 408-335-6444, and my email address is nipa@staffingme.com. But yes, don't forget to subscribe, share, and like our content. Our handle is @Immigration Talk Show. Check us out on LinkedIn, not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. Thank you once again, and stay tuned on Immigration Talk Show because there's a lot more coming, all on US immigration. Bye for now. Thank you, Jacob.
Thank you.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMMI Support.